Hello and welcome to True Crime Chat with Mommy Ramblings. I hope everyone's doing well. If you're new here, my name's Carolyn, and I encourage you to click the subscribe button on the lower corner of this video. Along with that, you should click on the bell so that you'll get notifications when we upload new videos or when we go live, which we do nearly every evening. We do a lot more than just true crime here. We have a wide variety of quality content. Anything from craft tutorials, recipe tutorials, cute puppy and dog videos, shopping hauls, outdoor travel videos, all kinds of things. You really never know what you'll find, but you'll find a variety, that's for darn sure. Okay, so I have some updates in the Lori Vallow Daybell case. Lori's only attorney left standing, Mark Means, is requesting discovery from the prosecution. And among those things requested, Tammy Daybell's autopsy report, Alex Cox's autopsy report, Charles Vallow's autopsy report, and Joseph Ryan's autopsy report. Okay, Lori's third husband and Tylee's father. He also has some issues with visiting Lori in jail, and that he wants a reduction in her already reduced bond. So you know what you need to do? You need to get your tiny violins out of their cases, get them ready, tune it up, because you're going to be playing that violin, because poor Lori. Come on, let's dig right in. Okay, so we know Lori Vallow Daybell is sitting in jail. She's charged with desertion and non-support of her missing children, one misdemeanor count of resisting and obstructing an officer, and solicitation of crime and contempt. As I just said, 2 of her 3 attorneys just up and left. They didn't give a reason why. They stepped down. That would be Edwina L. Cox and Brian Webb. Mark Means is the last one, the lone wolf there. And he is asking for documents from the discovery to the Madison County Prosecutor's Office. Okay, so let's see what's going on with that. The documents that Mark requested include the toxicology and autopsy reports for Charles Vallow, Joseph Ryan, both the ex-husbands of Lori Daybell, husbands 3 and 4 respectively, Alex Cox, her brother, toxicology and autopsy reports for Tammy Daybell. In case you missed that one, that's the late wife of Chad Daybell. She passed away in October, and Lori and Chad married 2 weeks later. He also wants the names of all the investigative authorities and officials, and 2 years worth of emails from Lori's computer, social media postings, dating and romantic website information, along with all financial records. In the request, Mark Means asked for all documents, recordings, written evidence, photographs, videos, records, reports, texts, emails, financials, and other information related to a lengthy list of individuals, including Kay and Larry Woodcock, J.J. Vallow's grandparents. Brandon Boudreau, he wants the records and everything for him as well, and that is Lori's former nephew-in-law, remember, married to Melanie, who's now married to Ian Pawlowski, right? Yes, follow this along. You need a flow chart. You need a, oh my goodness, you need a whiteboard. Who are we kidding here? Let's go. Now this request comes after Mark already received 1,600 pages of documents and records, along with 14.6 gigabytes of photos, videos, and other electronic information in preparation for Lori's preliminary hearing on May 7th and 8th. Means said the number will likely increase to over 10,000 pages and more than 200 gigabytes of files. One thing we do know is that Lori's been very tight-lipped. Those red lips have been sealed tightly shut. especially regarding her children. And that's why I found that this statement released to ABC News by Lori's lone attorney very interesting. So Mark Meehan said that, as with any citizen of our country, Mrs. Daybell is entitled to all the privileges and rights that accompany our cornerstone beliefs of innocent until proven beyond a reasonable doubt otherwise. It is in this innocence that Mrs. Daybell assertively maintains regarding all charges. Furthermore, Mrs. Daybell is guaranteed access to a fair and impartial judicial process. There is no room in this process for conjecture, innuendos, and/or speculation to alter this constitutionally guaranteed process. In the coming days, we look forward to the opportunity to work through the judicial process to prove Mrs. Daybell's innocence. And Mark filed a separate motion, requesting another hearing before the magistrate, Judge Michelle Mallard, to reduce Lori's already reduced $1 million bail. He wrote that a March 24th request for a bail reduction hearing had been ignored, and then on March 30th he traveled from Boise to Rexburg to visit with Lori at the Madison County Jail. Mark said, and I quote, "Upon arriving at said detention center, I was required, with no attorney-client option, to the sole option of communicating with my client in the public visitor meeting room, wall of glass between attorney and client, over a recorded telephone line," Means wrote. "I was told that the only way that my client could review documents was to pass possibly sensitive documents and records by and through a detention center officer from the public, my side of the room, round and about, through multiple security doors to an inmate client side, all of which would be out of sight of the attorney and client." Means said what happened was unreasonable and in direct violation of the regulations, law, and Constitution of the state of Idaho and the United States of America, and that the procedures prevent him from properly preparing for the preliminary hearing. In an objection to the bond reduction request, Madison County Prosecuting Attorney Rob Wood responded to Means and said the jail's visitation practices are due to the pandemic. What was the public visitation center is now being used for attorneys to visit their clients in a safe manner, which does not allow for the spread of the virus into the jail, Wood wrote. And Wood admitted the conversation between Lori and Means was accidentally recorded, but jail staff promptly deleted the recording. Delete. He said all recordings in the visiting area have now been blocked to prevent any further accidental tapings. Let's remember and recap that Mark Means already asked Magistrate Judge Farron Edens to drop Lori's bond from $5 million to $10,000 on March 6th. Edens lowered the amount to $1 million, and then Lori's dream team, Mark Meadows, that's all that's left, asked for that judge to be disqualified from the case. So Wood now says it has been less than 1 month since the court reduced Lori Vallow Daybell bail to $1 million, and it appears to be an abuse of the court rules for the defendant to disqualify the judge on the case and then to request the same or similar relief so soon thereafter. He also pointed out that Lori's children are still missing. He wrote, "The defendant has yet to comply with the valid court order to produce her children in the related child protection action." Further went on to write, "The court should make obedience to said order or show of good cause for why the defendant cannot obey said order condition for any further bail reduction. Okay, so let's look at some of these requests that were filed for discovery. And this first one, State of Ohio Plaintiff versus Lori Vallow, aka Lori Daybell. Please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules and all corresponding subsections, request discovery and inspection of the following: information, evidence, and materials. Any and all written, verbal statements of the defendant, witnesses, and or persons of knowledge and the like. 2. Defendant's prior records. 3. Reports of examinations and tests. 4. State witnesses. 5. Police reports, records. 6. All affidavits and or statements issued, created, drafted, written, stated by any and all police agencies investigating or involved in the above matter. Police, investigating entities, emails, text messages, voice messages, records, telephone call, text records, or the like to any persons contacted, communicated with regarding the above case, whether on police-issued communication devices or personal devices, for example, computer, cellular phone, text device, etc., from January 2019 to present or before said date if such communication occurred. 8. Cellular and internet provider contract information regarding all police authority investigating entity for both personal and city agency employment. Communication devices for each and every person or persons involved in the child welfare check relevant to this matter and or assigned on investigative duty regarding the above case. 9. List of any and all persons, full name, address, telephone number, email address, and any other corresponding contact information for any and all persons contacted by the Rexburg City Police, Madison County Sheriff's Department, and or other agency entity in regards to the above matter. Please include the following: detailed dates of said contact, communications, contents of communications, statements made by officers, entity, attorneys, description of how communication was conducted, telephone, cell phone, email, text messages, facsimile, or the like, etc. Copy of any of the contact communications, emails, texts, facsimiles, telephone records, call records, text logs, or the like between the investigating entity, police, deputy, or the like, and persons identified in these requests. Okay, it goes on to say they want copies of any and all audio and or video recordings, documents, records, etc. associated, related to, or relevant to the incidents alleged and or associated incidents and or events of which prosecution alleged or mentioned at the 3/6/20 arraignment bond hearing before this court. Furthermore, any and all records, recordings, documents, written evidence, photographs, videos, records, reports, texts, emails, financials, computer stored, obtained records, computer forensic reports of any and all electronic devices related to persons of interest or defendant or investigation related to persons of interest or defendant. 13. Toxicology report, autopsy reports, and any and all corresponding associated documents, records, testing results, procedures used, expert reports, notes, charts, chemical analysis, expert opinions, persons involved, identifying information, role of involvement, employment, title, position, education of persons, and or the like regarding The autopsy of the following: deceased, Mr. Charles Vallow, former husband of the defendant. Deceased, Mr. Alex Cox, brother of the defendant. Deceased, Mrs. Tammy Daybell, former spouse of Mr. Chad Daybell. Deceased, Mr. Joe Ryan, former husband of the defendant. Any and all records related to the following. Okay, include but not limited to Mr. Does that say? Why does that say Adam? It does say Adam, doesn't it? Mr. Adam Cox, Mr. Charles Vallow, Mr. Alex Cox, okay, so I just brought that footnote up that was on the previous page up here by itself, just so you could see better what it says. So it says, include but not limited to Mr. Adam Cox, Mr. Charles Vallow, Mr. Alex Cox, Mrs. Tammy Daybell, Mrs. Ethel K. Vallow, Mr. Larry Woodcock, Mr. Brandon Boudreau, Mrs. Melanie Pawlowski, formerly known as Melanie Boudreau, Mrs. Melanie Gibbs, Mrs. Christina Ashwood, Mr. Jack Daybell, Mrs. Sheila Daybell, Mr. Jason G. William, Mrs. Samantha William, Mr. Summer Shiflett, Mrs. Ruth Mortensen, Detective Hope of the Rexburg Police, Mrs. Heather Daybell, Mr. Matt Daybell. Investigation, including any and all requested records, etc., materials, files, records, reports regarding Mr. Charles Vallow, deceased husband of defendant. Please include all emails for the past 2 years from Mr. Vallow's Gmail email account. All social media postings, dating, romantic website, information, communications, all financial records, including but not limited to life insurance records, Chase credit accounts, UFCU Credit Union, Austin, Texas, U.S. Bank credit card, Chandler, Arizona Police Department records, reports, etc. All records from Mr. Charles Vallow's items which belong to the defendant, cellular telephone and laptop, and other items, properties in the possession of the Chandler, Arizona Police Department. Investigation, including any and all of the requested records, etc. above regarding Mr. Alex Cox, deceased brother of the defendant. Investigation, including any and all requested, etc. above regarding Mrs. Tammy Daybell, deceased. Investigation, including any and all requested, etc. above regarding Mr. Joe Ryan, deceased. All of the above related to or concerning the allegations made against the defendant in this case. Any and all of the above provided previously or in the future to the prosecution of the above case by and any all law enforcement agency, whether said agency be local, county, state, or federally associated, including but not limited to the city, county police, sheriff's department, and or Federal Bureau of Investigation, FBI. All audio, presentation, broadcasts, podcasts, presentation, or the like regarding the defendant involving defendant or mentioning the defendant. All records, texts, emails, documents, records, forensic computer electronic analysis records, school and education records, financial, institutional records, communications, videos, pictures, tangible evidence of minor child Joshua J.J. Vallow and Tylee Ryan, any and all other documents, records, exhibits, evidence, etc., that the prosecution intends to offer as evidence at the trial of this matter. The right is reserved to request further disclosure by order of the court if necessary and upon motion. The undersigned further requests that you provide discovery to our office within 15 days from the service thereof. The right is hereby resolved to make a request for such other and additional discovery as may be determined at a later date to be necessary and/or required. These requests are ongoing and require timely supplementation by the prosecution in this matter. Pursuant to Rule 16 of the Idaho Criminal Rules, this request relates to information in the possession or control of members of the prosecuting attorney's staff and to others who have participated in the investigation or evaluations of the case, who either regularly report or with reference to this particular case have reported to the office of the prosecuting attorney. Please note that all the above requests include requests for tangible, intangible exhibits, evidence, records, etc. of the above requested. Dated the 2nd day of April 2020, Mr. Mark L. Means. The undersigned certified on the 2nd day of April 2020. I caused a true and correct copy of the foregoing document to be forwarded by the methods indicated below to the following Madison County Prosecuting Attorney's Office. Okay, again, dated the 2nd day of April by Mark Means. Now we have another one. This is for declaration in support of defendant's amended motion for bond reduction. Okay, so let's just look at this. Comes now defendant Mrs. Lori Vallow Daybell by and through her attorney of record Mark L. Means of Means Law and Mediation. They hereby declare in support of her motion for amended motion for bond reduction as follows. Attorney Mark L. Means, being first duly sworn upon oath, deposes, declares, and says as follows. I am the attorney on record for the defendant, Mrs. Lori Vallow Daybell, that on or about 3/24/20 I caused to be filed with this court her declared motion for bond reduction. To date, no response or objection has been filed with the court, and despite requests for an oral in-court hearing on the above motion, no notice of availability of the court to hear such has been provided. That on or about 3/16/20, my office received approximately 1,600 pages of documents and records, as well as approximately 14.6 gigabytes of video, photographs, electronic, intangible production, and the like from the Madison County Prosecutor's Office. It is reasonable, anticipated that future production of documents, records, tangible, intangible records will be produced to defendant as acquired by the prosecution taking over 200 gigabytes, 10,000 pages of tangible records, etc. That on or about 3/30/20, I traveled to the Madison County Female Detention Center to meet with my client in preparation for the forthcoming preliminary hearing and to review said documents and records. Okay, upon arriving at the said detention center, I was required with no attorney-client option to the sole option of communicating with my client in the public visitor meeting room, wall of glass between attorney and client over a recorded line upon which my client was required to enter her inmate number for charges and consent to recording of said phone call prior to connection of the telephone lines. In addition, that I was told that the only way that my client could review documents was to pass sensitive documents records by and through a detention center officer from the public, my side of the room, round and about through multiple security doors to the inmate client side, all of which would be out of sight of the attorney and client. And this procedure is unreasonable and a direct violation of the regulations, law, and Constitution of the state of Idaho and the United States of America. This detention center procedure, unlawful restrictions have made it impossible to prepare said hearing to communicate with my client in a confidential, privileged manner, and to simply review productions of documents, records with my client to assist in her defense of the pending charges criminal complaint. That these unlawful restrictions, as well as no hearing allowed to date on the previously filed motion to reduce bond, are in violation of my client's basic due process rights specifically, but not limited to 1. Defendant's rights to effective assistance counsel, 2. Idaho Rules of Criminal Procedure, 3. Constitution of the State of Idaho, 4. Attorney-client privilege, 5. Code of Federal Regulations, Title 28, Judicial Administration, Chapter 5, Bureau of Prisons, Department of Justice, 6, as well as violations of the Constitution of the United States, including but not limited to Amendment 5, 6, 8, and 9. Again, we respectfully request oral argument on this motion before the Honorable Judge Mallard. This is to certify or declare under penalty of perjury pursuant to the law of the state of Idaho that the foregoing is true and correct. And that's Mark Means. Okay, and then this is the undersigned. Okay, we don't need to go through that again. Just, you can look at it for yourself. Okay, and this last one is the objection to the defendant's declared motion for bond reduction. This now comes the state of Idaho by and through the Madison County Prosecuting Attorney's Office and hereby objects to the defendant's declared motion for the bond reduction on the following grounds. And this is from the prosecution, okay? They are objecting to the reduction of bond, saying that 1, the defendant asked for her bail to be lowered to $10,000 or in the alternative, $50,000 on March 6th. Since that time, the defendant disqualified the sitting judge on the case. It has been less than 1 month since the court reduced the defendant's bail to $1 million, and it appears to be an abuse of the court rules for the defendant to disqualify the judge on the case and then to request the same or similar relief so soon thereafter. The defendant has yet to comply with the valid court order to produce her children in the related child protection action. The court should make obedience to said order or a show of good cause for why the defendant cannot obey said order a condition for any further bail reduction, right? In the declaration in support of defendant's amendment motion for bond reduction, paragraph 3, the defendant describes the large volume of received and anticipated discovery and the difficulty in providing the defendant with that discovery. It is important to note that the reason for the current visitation restrictions currently in place at Madison County Jail are a response to the recent virus outbreak. The safety of both the inmates and employees is of the utmost importance to Madison County, the Sheriff's Department, and the Prosecutor's Office. Upon receipt of the defendant's amended motion, the state has discussed violation protocols with the Madison County Jail. The state has been informed that what the defendant has called the public visitation room is no longer open to the public, and that all public visitation is currently done electronically. What was the public visitation center is now being used for attorneys to visit their clients in a safe manner, which does not allow for the spread of the virus into the jail. In regards to the defendant's claim that the attorney visitation being recorded, the state has learned that one conversation between the defendant and the attorney was accidentally recorded. The jail promptly deleted the recording of that conversation and has placed a block on all recordings in the current attorney-client visiting area to preclude any other accidental recordings. The state takes the rights of the defendant to receive and review discovery very seriously. As such, the state has visited with the jail and believes that there are options to provide the defendant with adequate access to discovery, which the state will discuss on a hearing in this matter, respectfully submitted this 7th day of April 2020. So there you have it. Okay. Yeah, that happened, they're saying, but look, it's fixed. There's no reason. They're not going to, they shouldn't reduce her bond because of that. You know, if she wants her to get out, then put up the money or be quiet. So there, that is what we have right there. And, you know, I mean, just a couple of other things that are going on with this case. And I just thought I'd bring them to you so that you're up to date. And again, put it in the playlist so that everything is there when this case does go to trial. All right, everyone, that is it for the updates right now in the Lori Vallow Daybell case. Chad is still sitting pretty free, and he's not arrested. He's not charged with anything just yet. That can change at any moment, and charges for Lori could change at any moment, where she could be getting slapped with more. Children have not been cited or located or found or anything, and they have been missing since September. So really nothing going on there, unfortunately. And again, I'm sorry, but I fear the worst. Pray for the best, fear the worst. But that's about it. So let me know what you think in the comments. We'll go back and forth, and also on the live tonight, you know, bring any questions there. Thank you so much for watching. If you like this video, if you could please give it a thumbs up, share it out where you can. That would be wonderful. It would really help out a lot. And I really appreciate you guys. I hope you're staying safe and sane in this insane time, right? Hang in there, guys. We're going to get through this together. I know it. I have faith. We're going to do it. Love you guys. See you later.